You're the best Jarrett's got?
All rise. The Honorable Judge Lawrence Adams presiding.
Ladies and gentlemen, court is now in session. People may proceed with their case.
Faisal Qadri stands accused of the crime of driving under the influence of an intoxicating beverage. I anticipate that you will hear, in the testimony of eyewitness Lucy Bates, that at approximately 1:45 p.m., she saw Mr. Qadri's vehicle weaving down Sunset Boulevard before crashing into a bus stop bench. I expect that you will hear Officer Underwood testify that Mr. Qadri was asked to perform a number of roadside tests to determine his sobriety. He was placed under arrest after failing to satisfactorily perform these tests. Listen carefully to the evidence, for it will show that on July 22nd, Mr. Qadri was driving while under the influence of alcohol to the degree that he could not operate a motor vehicle with the same care and caution as a sober person. At this time, the people call Lucy Bates to the stand.
You may proceed.
Directing your attention to the afternoon of July 22nd, did you at that time observe an auto accident?
No, I didn't see an accident. I just saw the truck sitting against the bench, so I called 911. I mean, it looked like someone needed help, so I tried to, be of service.
Isn't it true that you gave a different account to the 911 dispatcher?
Well, maybe.
Your Honor, at this time I would like to play the 911 tape.
Objection. Calls for hearsay.
Counselor, what is your legal response?
Your Honor, Lucy Bates made a recorded 911 call during which she made statements that are inconsistent with her current testimony. According to the evidence code regarding prior inconsistent statements, that recording is now admissible as proof of the accident as she witnessed it.
Objection overruled. You may play the tape.
Hello, 911 emergency line. Do you have an emergency?
Yeah, I want to report an accident I just saw happen. A car accident on Sunset and Kings Road.
Okay. Tell me what happened.
Well, I saw this car. It just kind of swerved into a bench on the corner there.
Is the driver in need of medical assistance?
Yeah, I think so. I mean, he slammed into it pretty hard.
Ms. Bates, was that your voice on the tape, and were you telling the truth to the 911 operator?
Yeah, I was, but see, the tape kind of jogged my memory just now. What happened was, I saw the truck swerving down the street, and then it slammed into the bench. That's when I ran to the payphone and called 911. By the time I got back, the cop was already helping the guy out of the truck.
Is the man who stepped out of the vehicle after the July 22nd accident here in the courtroom today?
Yes, he's the man sitting at that table right there.
No more questions, Your Honor.
Mr. Blaine?
Have you stopped soliciting business on Sunset Boulevard since you received a warning from your probation officer?
Objection. Irrelevant.
Objection sustained.
The accident occurred around 2 o'clock, did it not?
Yeah, I guess.
You couldn't see very clearly, could you? You couldn't see the man in the driver's seat before you went to make your phone call, could you?
No, I couldn't see him really well while he was in the car. The windows were all glary from the sun. He was just kind of like a shadow.
How long would you say that you were away from the scene when you called the police?
Only a minute or two.
Now, the driver got out of the vehicle and walked away from the accident scene while you were down the street on the phone, didn't he?
Objection calls for speculation.
Objection sustained. Please rephrase the question.
Isn't it possible that during the time that you were on the telephone, someone could have walked away from the car and made a call?
Sure. Anything's possible.
No further questions, Your Honor.
You may step down.
At this time, Your Honor, the people call Christina Travis to the stand.
Please state your name and qualifications for the record.
Yes, my name is Christina Travis. I'm a criminalist for the LA County Police Department. I have specific training in the collection and analysis of evidence relating to driving under the influence.
I will stipulate to Ms. Travis's expertise in those fields, Your Honor.
You may proceed.
How can you determine when a person is no longer able to operate a vehicle with the same care and caution as a sober person?
Well, in the state of California, an adult person's percentage of blood alcohol content is interpreted in the following way. If it is between 0.05 and 0.08, they are possibly to probably under the influence. If it's between 0.08 and 0.10, they are probably to definitely under the influence. And if it's from 0.10 and up, well, they are presumed to be under the influence of alcohol.
Ms. Travis, according to this document, what conclusion can be drawn regarding the defendant's level of intoxication?
Well, a person with a blood alcohol content of 0.17% would, in my opinion, be unable to drive a motor vehicle with the same care and caution as a sober person.
Ms. Travis, is this the handwriting analysis you performed on the defendant's charge card receipt?
Yes, I did. I compared the signature on the receipt to the defendant's signature on his booking statement. I formed the opinion that they were made by the same person.
Would you please tell the court how the intoximeter device is used to determine a person's blood alcohol level?
Yes. Well, anyone operating a vehicle who is suspected of being under the influence can be stopped and asked to take a blood alcohol level test. They have a choice of 3, breath, blood, or urine. For the breath test, the subject is asked to blow into a tube which is connected to an intoximeter device, and that is used to determine blood alcohol levels through gas chromatography.
Can you tell the court about the recent history of the particular device which was used to test Mr. Kadri's breath sample on July 22nd?
Yes, the devices are tested every 2 weeks with a breath sample of known alcohol content and then calibrated accordingly to ensure accuracy. If a machine doesn't read accordingly, then it is adjusted until it does.
No more questions, Your Honor.
Mr. Blaine?
Ms. Travis, isn't it true that intoximeters have a history of unreliability and that 2 breath samples are required to determine blood alcohol content?
Objection, compound question.
Objection sustained.
Ms. Travis, why are 2 intoximeter tests required for each subject as opposed to just 1 definitive breath sample?
State law requires 2 tests to make sure that the equipment is functioning properly. Now, 2 widely different readings would indicate either an equipment malfunction or an inadequate breath sample.
Ms. Travis, you wouldn't say that all machines are 100% reliable, would you?
Mr. Blaine, to my knowledge, nothing is 100% reliable.
Isn't it true that there are many variables which affect how a given amount of alcohol will affect a person, such as weight, their tolerance to alcohol, and the amount of time lapse since consumption?
Yes, of course there are. And that's why we consider the field sobriety tests, in addition to the officer's observations, as well as the blood alcohol content. We're not operating in a vacuum here, Mr. Blaine. We use every method we have to ensure the accurate determination regarding a person's ability to drive a motor vehicle.
But you weren't with my client the afternoon of the alleged accident, were you?
No, Mr. Blaine, I was not.
No further questions.
You may step down.
Your Honor, the people call Officer Underwood to the stand.
Please state your name and qualifications for the record.
My name is Chris Underwood. I am a police officer for the Los Angeles Police Department and the arresting officer in this case.
Did you administer a blood alcohol test to the defendant?
Yes, I did an intoximeter test, also known as a breath test. The readings for his 2 samples were 0.17% and 0.18%.
Can you identify this charge card receipt?
Yes, I removed that receipt from Mr. Kadri's vehicle after I arrested him.
Please describe the scene at Sunset and Kings Road as you found it on July 22nd.
Well, when I arrived, I observed a white Dodge pickup stopped against a bus stop bench, and the driver, Faisal Kadri, was slumped over the wheel. When I opened the door, I noted a strong alcohol smell and immediately suspected that Mr. Kadri might be intoxicated. I shook him awake and asked him to step out of the vehicle.
Objection. Your Honor, Officer Underwood has not demonstrated that he had probable cause to pull my client from his vehicle.
Counselors, I'd like to see you at sidebar. What's your legal response?
According to People v. Pearsall, if a person is asleep in his vehicle on a public street, an officer has the authority to ask him to step out of the car to find out why.
Objection overruled. You may proceed, Counselor.
Please tell the court what happened next.
Mr. Kadri got out of the vehicle and stepped up to the curb, but I noticed he was kind of shaky on his feet. Plus, he appeared to be confused. His speech was thick and slurred, his eyes were bloodshot, and his breath smelled as if he had been drinking an alcoholic beverage. Combination of these symptoms indicated me that the subject was definitely inebriated. I administered the field sobriety test, which Mr. Kadri performed unsatisfactorily, and then arrested him for driving under the influence.
What does this accident diagram depict?
Yes, this is a diagram that shows the unreasonable driving of the defendant.
Officer Underwood, on July 22nd, did you administer this field sobriety test to the defendant?
Yes, that's the tape of the FSTs I gave Mr. Kadri on July 22nd. They're simple tests used to determine whether or not a driver's thinking and motor skills have been impaired by alcohol. Things any 6-year-old could handle with no problem, but in this case, Mr. Kadri failed.
Officer Underwood, can you tell me what this photograph is?
Yes, that's a picture of Mr. Kadri's vehicle, a 1990 Dodge pickup.
No more questions, Your Honor.
Mr. Blaine?
Officer Underwood, isn't it true that a person must first drive a vehicle before he can be found guilty of driving under the influence?
Yes, sir, that's...
And yet you never saw the defendant actually operate the vehicle, did you?
No, sir, I did not. I arrived on the scene after the accident had occurred.
Your Honor, at this time, I would like to make a motion to exclude all evidence following the arrest because the defendant was arrested for a misdemeanor not committed in the presence of the officer.
Counselors, I'd like to see you at sidebar. What's your legal response?
If this were any other type of misdemeanor offense, Mr. Blaine would be correct. However, according to the Vehicle Code, an officer may arrest for an offense that wasn't committed in his presence under one condition: if the person has been involved in a traffic accident and the officer has reason to believe that the person was driving while under the influence.
Motion denied. Nice try, Mr. Blaine, but not this time. Proceed, Counselor.
Officer Underwood, you mentioned that upon opening Mr. Kadri's door, you noticed a strong smell of alcoholic beverage. Is that right?
Yes, sir.
But there were also several pairs of coveralls behind the car seat that were encrusted with oil-based paint. Couldn't the fumes from these coveralls have either overpowered or been mistaken for an alcohol scent?
Objection, compound question.
Objection sustained. Please rephrase the question.
Isn't it possible that the paint on the coveralls emitted a strong odor which you mistook for alcohol?
I can tell the difference between the two odors, Mr. Blaine.
Since the defendant sustained a concussion during the accident, doesn't it naturally follow that he would have appeared sluggish and disoriented due to his injuries?
Objection calls for speculation.
Objection sustained.
Isn't it possible that the defendant could have appeared confused and lethargic following his accident without being under the influence of alcohol?
It is possible, of course.
No further questions.
You may step down.
At this time, Your Honor, the people rest.
Your Honor, I would like to make a motion to dismiss this case due to the insufficiency of the evidence.
Motion denied. At this time, the court is adjourned until tomorrow, at which time we will proceed with the case for the defense. Counselor, please approach the bench. I think you convinced the jury that the defendants are criminal. Nice work today. Oh, by the way, if you're looking for a place to have dinner, I'd recommend the Daily Grounds. It's overpriced, and the food's only so-so, but you can't beat the location and the atmosphere. It's just around the corner.
Hey, counselor! Hot party or act in court today. Had to cut out early because I had to get back here for the dinner rush. There are too many drunk drivers on the road today, that's for sure. Oh, you need anything, give a holler.
Counselor, what drives a man to drink? To seek solace at the bottom of the bottle. Just one for the road, then another, and another. How many people sitting in the courtroom today driven home late some night after having one too many? Had trouble changing lanes, sweating the curve on the off-ramp, dinged the bumper of their fancy car pulling into the garage. Things would be different if they'd 86 some kid on the way home. There they'd be, sitting in the back of a squad car, wailing about how sorry they are. All the time trying to remember the name of a good attorney. They were lucky. They all made it home safe, else they wouldn't be sitting here today. Who knows? Maybe, after a long day in court due to extenuating circumstances, they go out and have a drink. Then another, and then they get in their car and drive home.